The independent contractor puzzle is getting more and more complicated with the changing workforce, the changing economy, and changing technology. So part of the challenge is the proliferation of on-demand providers, on-demand services, the Ubers and Lyfts of the world. That's certainly changing things, but also workforce demographics, and younger generation of workers that actually often are looking for short-term gig, if you will, relationships.
Today we talked a lot about the relationship and the classification of independent contractors versus employees and what that means for both businesses when they're trying to set up a business or when they have ongoing concerns, and what it means for employees if they're not being paid properly and what they can maybe do about it. There's a big increase in the number of independent contractors around the state and throughout the country. So employers and businesses aren't wanting to have people with long-term relationships necessarily. They're trying to keep payroll down and perhaps use independent contractors more. So because of that, there's a big push to make sure that the tests associated with deciding who's an employee versus an independent contractor are well thought out and well dealt with, both from a business side, and then if there is a dispute for the employees, that people can navigate those in litigation if necessary. When someone comes to me for help, it's because they think they haven't been paid properly, or they've been classified as an independent contractor and they think they're an employee. So an independent contractor isn't going to get paid overtime, for example. And if they believe that they're really an employee and they should be getting paid overtime, then we may have a wage and hour complaint that we are able to bring forward for them. Since the end of the Obama administration and the beginning of the Trump administration, there's been a lot of changes on the regulatory side, and the Department of Labor has issued some different missives, if you will, in the last year. In addition, there's been some seminal case law that's come out, one in California dealing with certain new tests to decide between independent contractor and employee. And then earlier in May, there was a decision from the Supreme Court of the United States dealing with arbitration provisions and the right of employees to be able to band together in a collective action to bring forth a wage dispute. And the Supreme Court of the United States said that it's okay for employers to have arbitration provisions in the employment context, and also to ban class or collective actions as it relates to employment disputes.
I gave the government's perspective, the Department of Workforce Development's perspective, from our many enforcement agencies, the Unemployment Insurance Division, the Workers' Compensation Division, and the division I work for, the Equal Rights Division. So I can speak mostly from the Labor Standards Bureau, our position on those things. We take wage claims. When somebody doesn't get paid correctly, they come to us, they file a labor standards complaint. And if we look at one of those complaints, and generally speaking, somebody will tell us they think I'm an independent contractor, but I don't think I am, and I wasn't paid properly. I didn't get the wages I should have been paid. So then we'll investigate and try to determine whether they were properly classified as independent contractors or as should they have been employees instead. If we find they're employees and should have been paid differently, we'll require some payment from the employer. I think for the most part, employers aren't doing this intentionally. They just hear from somebody that, oh, I have somebody and I pay them on a 1099. Meaning I classify them as independent contractors. They think that that's okay given whatever circumstances come up. We find out, when they find out later that they've done it improperly, usually they're very amenable to remedying the situation. In the independent contractor world, there are different definitions of who can be an independent contractor based on which law you're looking at. So they really need to either have the services of an attorney who can navigate this, or to ensure that they understand that somebody may be an employee for unemployment insurance purposes and still be an independent contractor for other purposes. The Department of Workforce Development has a very good website. If you Google Wisconsin misclassification, you'll get right to that page, and you'll find all the tests under the laws we enforce, and it's really helpful.
The biggest challenge for employers in this area of law is determining which laws apply and which tests apply. And the challenge there is it varies from state to state. It varies within each state. Even here in the state of Wisconsin, there's different tests for independent contractor status under workers' compensation law, under the UI statute, under the labor standards statutes. And then we have case law or common law established tests as well. It can be very challenging for employers. Oftentimes, Wisconsin employers don't have an appreciation for the many different facets of the relationship with the independent worker that they need to consider. They may think as long as they're not giving much direction and control, that they will therefore satisfy all other factors under all of the other relevant tests, and that the worker's properly classified as an independent contractor, when in reality, direction and control is just one piece of the puzzle.
From a practical perspective, what employers should consider when they are engaging independent contractors. So what should be in a proper independent contractor agreement, what provisions you should have in there, what provisions it's recommended that you not have in there. And then also equally, if not more important, is how you are engaging with this independent contractor on a day-to-day basis during the period for which you've retained them and the services for which you've retained them. So you may have the best independent contractor agreement, but if you're treating that worker like an employee, it's going to skew the whole classification. As we are becoming much more of a global economy, we have clients who, while they may be based here in Wisconsin, they have employees and independent contractors all over the country. So it's very important for our employer clients to be mindful not only of Wisconsin law, but also if the states in which they have these independent contractors may have some unique requirements or even a full designated law focused on the independent contractor or case law or whatever. It's fast growing. It's not only in the gig, but also just even conventional employers are now, there's much more of a trend to subcontract out for areas of specialty that are not within your wheelhouse.